This isn't just a crash case. This is a courtroom chess match where every word, every objection, and every tiny detail could decide whether this turns into a manslaughter conviction or reasonable doubt. We've got surveillance footage, a detective trying to explain what happened in seconds before impact, and a defense attorney ready to tear that story apart piece by piece. But here's the twist: this case isn't about what happened, it's about what can actually be proven. And as you're about to see, proving something in court is a lot harder than just saying it. Stay locked in, because things get technical and messy fast.
All right, everyone, you may be seated. And if you could restate your name for the record, please. Restate your name.
Brad Armstrong.
All right, you're still under oath. All right, ladies and gentlemen, we do have a second court reporter in training who's sitting there. So again, the official record is with Cindy, the court reporter, and she's in training. All right, stated still your witness and you're still under oath. You may proceed.
Thank you, Judge. All right, so to keep going from yesterday, Detective, did you receive video from Albert Perkins regarding the crash?
I'm sorry, who?
From an Albert Perkins, did you receive video of the collision?
So from the, there's a bar correct directly behind it. Yes.
Yeah, that's correct. Did you receive video from that collision?
Yes. I
From
did.
that bar? Okay.
Now this is where things get interesting. The video evidence comes in. In any crash case, video is powerful, but it's also dangerous. Why? Because what you think you see isn't always what you can legally prove. The prosecution is trying to use this footage to show behavior, speeding, failure to slow down, running a light. But here's the catch: unless a witness can clearly and definitively interpret what's happening, it risks being labeled as speculation. So ask yourself, when you watch a crash video, are you seeing facts or making assumptions?
First of the record, be playing state exhibit number 2. Detective, do you have a view of the video up there?
I do.
Okay. Go to tools, effects, video effects, geometry, interactive. I'm gonna pause it right here. Detective, are you familiar with the Texas Transportation Code?
Yes, I am.
Are you familiar with the duty of a driver is under the Texas Transportation Code when a light turns yellow?
Yes, they're supposed to slow down.
They're supposed to slow down? Okay. Let me actually rewind that a little bit. So Detective, based on this video, Unit 2 is parked here, right?
Yes, right behind that sign.
And this vehicle over here, is this Unit 1?
Yes, that'll be unit 1.
Okay. Pause it there. Was the light yellow in the video that we just saw?
It was, and now it's red. It changed to red.
Does it appear that Unit 1 was slowing down while the light was yellow?
I'm gonna object. Cause
And
for
here's a courtroom masterclass in objections. The defense keeps shutting down the same line of questioning, speculation. And the judge keeps agreeing. That's not random, that's strategy. In court, a witness can't guess. They can only testify to what they directly observe. Saying a car looked like it was speeding or seemed to not slow down isn't enough. It has to be measurable or clearly supported. What we're seeing here is the prosecution struggling to translate video into legally acceptable testimony. And right now, they're losing that
I'm
battle.
gonna object. Cause for speculation.
Sustained.
What appeared to be the behavior of Unit 1 while from your perception, what was the behavior? Judge, he's allowed to,
Well, here's the thing. I need to hear the question,
of course.
and then I'll hear the objection, and then I'll rule on the objection.
What was the behavior of Unit 1 in the video here? Was he slowing down during the red or during the yellow?
I'm gonna object again, Judge. This is the same question. Calls for speculation.
All right. Response to speculation.
Judge, I'm asking him what the behavior of this vehicle is based on his perception of the evidence in front of him.
Right, that objection will be sustained.
Okay. What is the behavior of the vehicles in this video?
I'm gonna object. Calls for speculation.
Sustained.
What do you observe the vehicles to be doing in this video?
So what I see is the unit 2 at the light, waiting for a green light. I see the other vehicles approaching. I see there's one light that maintains and holds speed. The other two,
Notice how the detective is forced to rephrase everything. Instead of saying this car was speeding, he has to describe gaps, positions, and movement without drawing conclusions. That's a huge limitation. Because in a case like this, the jury wants a clear story, who messed up and how. But legally, the witness can't tell that story unless it's backed by solid, non-speculative evidence. So the big question becomes, can the prosecution still prove recklessness without directly saying it?
the other two behind it appear to be slowing down.
I'm just gonna object to any appearing to be slowing down or the speed of any vehicles, as that is speculation. You cannot tell the speed of any vehicles in this video.
Sustained.
What do you observe about the other vehicles other than Unit 2 and Unit 1?
What I observe is that the other lights behind what we call Unit 1 they have a significant gap between Unit 1 and the other vehicles behind them.
Does there appear to be a difference from what you observe? Does there appear to be a difference of speed between Unit 1 and the other vehicles?
I'm gonna object to leading in speculation.
Sustained.
From what you observe, what are your observations of Unit 1's speed compared to the other vehicles on the roadway?
Judge, this is the same question. I'm objecting to speculation.
Sustained.
Let's go to your investigation supplements. Detective, on page, if I can direct your attention to page 2 of your investigation reports. Did you receive word whether Mr. Fernandez had passed away?
Yes, I did. I put on there that he succumbed to his death, injuries, succumbed to his injuries.
Detective, is it your decision after you complete an investigation whether to make an arrest or not?
It is.
What is that? What is the decision to make that arrest based on?
At the scene, I have to have the full probable cause, a complete investigation with all the facts, everything together, to be able to put a charge on there.
Okay. And what factors were you basing this arrest on?
There was a death of a driver. That's one factor. For another vehicle involved, if they're basically driving reckless, basically
Now we finally hear the foundation of the case, why the arrest happened. Speeding and running a red light. That's it. Those two factors are what elevate this from a simple accident to a potential manslaughter charge. But here's where it gets tricky. Both of those claims must be proven beyond reasonable doubt. And so far, we've already seen the court reject multiple attempts to establish speed from the video. So now you have to wonder, does the prosecution actually have strong enough evidence, or just a theory?
Basically, there could be a number of things, and this is what I'm looking for: observed speeding and disregarding red light.
Okay. So just to summarize, it was based on speeding and disregarding a traffic signal?
Correct. Those are the two factors that I observed. I have to have more than one at least to be able to put that into a manslaughter case.
During your investigation, were there any signs that Simon Garza took any evasive action prior to the crash?
I'm sorry.
Based on your investigation, was there any evidence, anything that showed that Simon Garza took evasive action prior to the crash?
No, there's, I could put basically off the data that I collected. He did apply his brakes a second before the crash, but no, from the video, I can't see any try to avoid, try to move, slow down when the yellow light came on or the red light came on.
I object that this is speculation from the video, Judge.
All right, that would be sustained as to speculation.
And I'd ask,
Yes.
I'm sorry, I didn't mean to interrupt. I thought you were done, Judge. I'm asked the jury to disregard.
All right, ladies and gentlemen, you're to disregard the last answer and state you'll need to lay foundation.
Thank you, Judge. Detective, I'm going to direct you to the ACM data that you have in front of you.
Okay.
So just refresh your memory off of that. Was there any sign that Simon Garza's vehicle was containing a constant speed prior to the crash?
I'm going to object cause for speculation.
All right, and what report is he reviewing?
He's reviewing the ACM report that was used for his recorded
Has
recollection.
it been admitted into evidence?
It has not been admitted, Judge. It's been used to refresh his recollection.
All right, the objection will be overruled.
You can answer.
Okay.
This is a critical turning point. The ACM data comes in. Unlike video interpretation, this is machine data. Hard numbers. Engine throttle, braking timing. This is the kind of evidence courts love because it removes guesswork. And what does it show? The driver maintained speed until just 1 second before impact, then hit the brakes. That's powerful, because it suggests there was no early attempt to slow down. But here's the flip side. Does braking 1 second before impact prove recklessness, or just a late reaction?
Okay. Based off the ACM collection data, it shows that the vehicle maintained the engine throttle speed. That's basically how the speed of the engine's moving. It made a constant speed up to 1 second prior to the crash.
Okay. What happened 1 second prior to the crash?
It shows that the accelerator, the throttle was let off, so it went to 0, and then half a second after that, the service brake was applied. Service brake, sorry.
To your knowledge, did the ACM show any kind of maneuvering or turning out of the way?
This ACM, like I said, is restricted. Some show that, but this one does not show steering inputs.
Okay. Now, based on your investigation, do you believe you have probable cause to make an arrest?
I do.
Did you file for an arrest warrant on Simon Garza?
I did not file for an arrest warrant. I filed at large.
And there it is, the charge, manslaughter. This is serious. This isn't just about fault anymore. It's about criminal responsibility for a death. To prove this, the prosecution must show not just that a mistake happened, but that it was reckless or negligent enough to be criminal. So everything we've seen so far, the video, the data, the timing, it all feeds into one question. Was this a tragic accident or a crime?
Thank you, filed at large. And what was the charge that you filed the arrest on?
For manslaughter.
Okay, thank you. Judge will pass the witness.
All right, defense.
Thank you, Judge. Hi, Detective.
Hello.
How are you?
Good.
Good. My name is Marissa Javenko. I'm representing Mr. Garza. If you don't understand my questions, can't hear me, just let me know, okay?
Yes.
Okay. I know we talked about this yesterday, but I want to make sure it's clear. How long have you been a certified peace officer?
Coming up about 13 years, so 12 years and 9 months, maybe
Okay.
10 months.
And so I think I misheard you. You said you made detective in what year?
2023.
Okay, so if I heard 2003, that was way wrong.
Right.
Okay. Just making sure. And so since 2023, have you been in TID?
I was in TID for 2 years. Yes.
Okay. So you're no longer in TID.
No, I'm not.
Okay. But at the time of this incident, October of 2023, you were a detective in TID.
That is correct.
And what does TID stand for?
Traffic Investigation Detail.
Okay. Oh, at this accident, or at the time of this incident, how long had you been with TID?
At the time of this accident, so I got there in May. Let's see, sorry, repress the date. October. So
October.
we're looking at 5 months in TID.
Okay. All
Excuse
right.
me, just give me one moment.
Yes.
Everyone can remain seated. Sorry about that, everyone. Oh, please be seated. All right, you may continue. Yes.
Okay. Detective, you had said, so at the point of this accident, you had been with traffic investigations for 5 months.
That's correct.
So yesterday, you testified that you had investigated probably over 1,000 crashes and 200 death cases, correct?
Throughout my career, correct.
Now the defense flips the script and goes after the detective. They're not arguing the crash yet, they're attacking credibility. Yes, the detective has years of experience overall, but at the time of this crash, only 5 months in that specialized unit. That's huge, because the defense is planting doubt. Was this investigation handled by someone fully experienced or someone still learning?
My career, correct.
Right. So at this point, when this happened, you were not anywhere near those numbers.
No, that's throughout my career. You still investigate a crash as an officer.
Okay. So in 2023, October of 2023, about how many crashes had you investigated at that point as a detective?
I'd have to go back and look at the numbers at that time. I don't, you're talking about through TID or completely through my career?
As a detective.
As a detective, I had to go back and look at the numbers. I don't have those exact numbers.
Okay. Um, you testified that a lot goes into crash reconstruction, correct?
That's correct.
And in fact, there's a lot of math that goes into a crash reconstruction.
Right, it can be, yes.
Okay, it can be. So do you not always do math in crash reconstruction?
As I explained yesterday, is that when a vehicle moves, it's not locked in that position. The parameters have been taken out, so that part of it you can't use. So there's several formulas that you can use. So let's say there's 30 different equations that you can use for calculating a speed or movement. Some of them are taken away due to parameters that are outside of our control. And we use what we can use.
Okay. And so are you saying, I'm not sure you answered my question. Do you use math in every crash reconstruction or not?
Not in every reconstruction, that's correct, no.
Okay. So did you do any math or any equations to figure out the crash reconstruction in Simon's case?
On this one, there was not enough evidence to be able to put down on paper because you need several variables in a math equation. You need all of them to fit in there to be able to get an accurate number. So we didn't use that on there.
Okay, so no equations were done in this
This
case.
is one of the biggest blows to the prosecution. No calculations, no equations, no reconstruction math. In crash investigations, math is often what turns opinions into facts. Without it, conclusions rely more on interpretation, and interpretation can be challenged. The detective explains why, missing variables, but the damage is already done. Because now the jury might be thinking,
Equations were done in this case.
Well, we attempted many, we just couldn't actually get any that would, because you need all the parameters.
Okay. And so when you attempted, do you document that attempt?
No, that's just in my head using, scratch paper, something like that. That's just working in your desk.
Okay. But so the end result is there was no math, no equations to reconstruct this accident.
Right. Again, you don't need them for every equation or every crash. You don't need it. So like I said, if it fits, we can use it. So basically you pull out your sheet, your chart of your equations. If it says you need A, B, and C, well, if you have A and B, you don't have C, you can't do it. So you attempt it, but if it's not there, you can't do it.
And you would agree with me, there a lot of factors go into a crash and what happens in an accident.
There can be a lot of factors, yes.
Okay. I mean, the conditions of the roadway would be a factor,
Conditions of the roadway can be a factor, yes.
right? The weight of the vehicle can be a factor, correct?
Yes, weight are also calculated.
Okay. What about the year and make and model of the vehicle? That also can be a factor.
Not so much overall, just basically the capabilities of the manufacturer, what the capabilities the manufacturer have for each year. That's the only thing that really changes.
Okay, so are you specifying that a crash between an F-250 is not going to be different than the crash with a smart car?
No, that's what I'm saying. Those are weights. Those are different. Yeah, those are different.
Okay.
Again, applying a brake, making a brake come on, the speed of the vehicle, those remain the same.
Sure, but the year of the vehicle, safety features in vehicles have improved drastically over the years.
Yes.
Okay, so the safety features of a 2026 vehicle is going to be different than, say, a 1996 vehicle.
That's correct.
Okay. Yesterday, the state was attempting to ask you about what speed would be a survivable crash, but all of those factors go into it. Speed is not the only factor to determine whether someone survives the crash, correct?
That is correct. There are different things that could go on.
In fact, more than I mentioned already. We've got whether they were wearing a seatbelt, the point of the impact, alcohol and drug use, whether airbags went off, pre-existing conditions. All of that goes into whether or not someone survives an accident.
That could work as well. Yes. Again, those are more for like a medical type thing, but like I said, ours focuses on the speed. impact.
Sure. But there's no set speed that determines whether or not someone survives a crash.
There's no set speed. I just go off my observation when I've seen many crashes. Again, experience seeing many survival crashes at 25, 30 miles an hour.
But that's not a guarantee. There's no set speed that people die at.
There are no guarantees.
Right. Okay. And you got to the scene and you one of the first things you did was you talked to my client, correct?
That is that's not the first thing I did, but that's what's recorded. Because again, in our set and operating procedure, we don't have to record the whole scene we're there. It's just when we interact with a witness, driver, or something like that.
Okay. And actually you testified that one of the first things you do is you look at the vehicles then.
That's correct.
Is that what you did in this case?
Like I said, I do the same thing every time. Talk to the officers, go to the vehicle, look at the video, look at the vehicle, look at the scene, and then I'll talk to the drivers.
Okay. So you talked to all the officers that were at the scene?
No, I do not talk to the handling officer.
Okay. And in fact, you actually, when you got to the scene, you were under the impression that there were witnesses to the offense or to the accident, correct?
When I got there,
Yeah.
again, I don't get that until I get to talk to the officer. I don't know if there's, I mean, because witnesses can leave. I have no idea. Until I talk to the officer, I won't know.
Okay, but that wasn't my question. My question was, when you got to the scene, you were under the impression that there were witnesses to the accident.
Under the pressure, well, under the pressure means I already knew, but I didn't know until I was told by an officer.
Okay. Do you remember making a statement to the handling officer that you thought that there were witnesses?
No.
Okay. Would refreshing your memory with your body cam, or would watching your body cam help refresh your memory?
Sure. I always say there's always witnesses. Like I said, just are they there? Can I talk to them? That's all I want to know is can I talk to them?
Okay. For now we'll move on. You in reviewing your case for your investigation, you review all of the body cameras and reports of other officers?
Yes.
Okay. And so in reviewing those body cameras, you're aware that there actually was a witness who said that Jose Fernandez ran the red light.
Now we hit a major credibility issue: witnesses. The defense tries to introduce a statement suggesting the other driver may have run the red light, but it gets shut down as hearsay. Still, the seed is planted. Even though the jury is told to ignore it, psychologically, it's hard to unhear something like that. And this is classic defense strategy, introduced out, even if it doesn't fully land. So now the narrative isn't so clean anymore.
Light.
Judge, I'm gonna object to that. That's hearsay.
Sustain as to hearsay.
Judge, we'd ask this jury be instructed to disregard the last question.
All right, ladies and gentlemen, you're instructed to disregard the answer to the last question. Or I'm sorry, the question.
Sure. So you're aware that there actually was a witness to this accident?
Yes, the officer told me that the driver, like I said, he's considered a witness to me. He observed what happened. So yes, there is a witness. Is who I talked to is the driver.
Okay. If you testified that you watched all of the body camera from other officers at the scene of this offense, correct?
Yes.
Okay. In watching that, you're aware that there was a neutral, not involved witness to this crash, correct?
Judge, I'm gonna object to this. This is hearsay, and it's also been asked and answered.
All right, that objection will be overruled.
You can answer the question.
Oh, yeah. Like I said, I do not recall that, or else I'd have put it in the report.
When you talked to Simon, he was answering the questions. In fact, I think you testified to this yesterday. He was kind of answering them a little slow, correct?
That is correct.
Okay. He had just been in an accident.
That is correct.
Did you ask him if he hit his head?
No, I did not.
Okay. And so it's possible he was in shock.
Like I said, I don't know what he normally talks like. Like I said, I just mentioned that is watching the video. It looks kind of slow, but again, I'm listening for slurred speech. Again, red glass over eyes, stuff like that.
Sure, but that wasn't there. There were no signs of intoxication. correct?
Correct.
Okay. But he had just been in a serious automobile accident, and it's possible he was in shock.
I'm not like I said, I'm not a doctor. I don't really know. I mean,
Sure, but Detective, you've testified that you've worked thousands of automobile accidents. Is it not common for people to be in shock after getting into a vehicle accident?
This moment is subtle, but powerful. The defense suggests the driver may have been in shock after the crash. Why does that matter? Because it affects how reliable his statements were at the scene. If someone is disoriented, confused, or traumatized, their recollection might not be accurate. And that creates doubt about everything he said, including not knowing the light color. So now we're questioning not just the crash, but the statements after it.
yes, of course, usually they'll get checked out by medical. Medical will give the clear. That's why I said they're already gone. Medical gives the clear. That's why I'm talking to him, not I'm talking to him in an ambulance or at the hospital.
Sure, I'm not asking you to make a medical diagnosis. I'm only asking you if it was possible.
Like I said, anything in the world is possible.
Okay. And when you talked to Simon, he actually told you that he didn't know what color the light was, but that the lady told him the light was red.
That's what I recall from watching the video yesterday. Yes.
Okay. And you checked Simon's phone. There was no evidence that he was using his phone or distracted by his phone.
The two items that I checked were usually text and calls. There's other things you can use in your phone that won't show up. I mean, if you're watching a video or something like that, you can't see that. Kind of hard to get into a phone. You can't, like I said, if you watch a video on your phone, I can't tell exactly when you watched it. I'm just taking the ones things that we can know.
To non-responsive and narrative.
Sustain.
If you can just listen to my question, there was no evidence that he was using his phone.
There's no evidence that I observed.
Thank you. And in putting together your packet and everything for the district attorney's office, did you also review the EMS records?
I did not.
You did not. Okay. Excuse me. So are you aware that there is conflicting evidence on whether Jose Fernandez was actually wearing a seatbelt or not?
I don't have that information. I just know what I see at the scene is that a seatbelt was worn.
Okay. However, you yourself have actually made a statement that he was not wearing a seatbelt. You remember that?
I don't recall.
Okay. Would watching your body worn camera refresh your memory?
Sure.
Okay. Judge, can we take a break to do that?
Yes.
At this point.
All right, ladies and gentlemen, we'll take a 10-minute break. Please remember my previous instructions.
All right for the drink.
A bunch, I'll show you some. About a bunch. Yeah.
Lauren, are you able to take this plea?
Yeah.
You good?
Yeah, it's David Gonzalez. I'll walk you through the. All right, the court is calling 2026 CR 001813, State versus David Lopez Gonzalez. Can I have parties announced for the record? And are you Mr. Gonzalez? Counsel, have you received all discovery? Did you review it with your client? Court will find that the state is in compliance with discovery. Mr. Gonzalez, did you review the application for community supervision with your attorney? Did you understand it? Did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment? All right, State, it appears that you're proceeding on the indictment as presented. Is that correct?
Yes, Judge.
All right. Mr. Gonzalez, did you review the court's admonishments with your attorney? Did you understand it and sign it in all the appropriate places? You're charged with unauthorized use of a vehicle as a repeater. So the range of punishment, if the state approves it, the enhancement is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses? Do you believe he has a rational as well as a factual understanding of the charges against him? Do you believe he's currently competent and was legally sane at the time of the offense? Mr. Gonzalez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? According to the plea, punishment is to be assessed at 4 years in the prison. You agree that you've been previously convicted of 2 or more felonies for purposes of enhancement. There's a $1,000 fine. The state is opposed to your application. They're taking in consideration 2025 PF 49447 and 2025 PF 49446. Did you understand that to be the plea? Defense is at the plea. State is at the plea.
Yes, sir.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? By signing that you're waiving your right to appeal, the only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions? Outside the agreement, there's to be no contact with the complainant. Did you understand those are recommendations from the state and the court does not have to follow those recommendations? Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? To the enhancements, how do you plead? True or not true? State any evidence. All right, did you review the state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, state in this case, off the record for a moment. Yeah, I just needed, who is S1, the identifiers for that. Unless there's a stipulation that P1 and S1 are the same.
What I tendered to the court judge is there's the initial report of the theft. P1 is listed as Vivian. And then on the pros guide, it should say S1 is. I'm remembering.
Okay, let me see if let me hand it to you and maybe I'm missing something. You're welcome. Okay. Mr. Gonzalez, are you stipulating that the person listed in the waiver and stipulations? Just one moment. That you were the driver of the vehicle? Are you stipulating that you were the driver of the vehicle? All right, after viewing States Exhibits 1 and attachments and with the stipulations, the court will find there's sufficient evidence to find you guilty. The court will find you guilty. The court will find the enhancements true based upon your plea of true and based upon States Exhibits 1 and attachments. State is opposed. Are you requesting a PSI? All right, I need a PSI date, please. No, he's on bond. PSI and TAP evaluation. All right, once you sign the reset form, you'll be excused. Make sure that you make all of the appointments that are scheduled for you through probation. All right, thank you. Who's next?
This case comes down to one thing: proof versus possibility. The prosecution built their case on video interpretation, officer testimony, and vehicle data suggesting late braking and possible traffic violations. But the defense systematically chipped away, highlighting speculation, lack of hard calculations, limited experience at the time of investigation, and missing or conflicting evidence like witnesses and driver condition. And that's the reality of courtroom battles. It's not about what might have happened. It's about what can be proven beyond reasonable doubt. So now I want to hear from you. Do you think this was reckless driving or just a tragic accident? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.